the giving of the statement was free of threats, inducements, and promises of benefit. Ms. Ryder's statement falls short of that standard. Ms. Ryder's confusion, coupled with the perceived intimidation that comes from being locked in the back of a police cruiser, resulted in a statement that was coerced. Ms. Ryder testified that she's never been in the back of a police cruiser, and she had likened it to a jail cell she had seen on TV. She was told by the officer she didn't have to make a statement, but then the officer turned around and asked her what happened. The officer is in the power position. He should know what to say, how to say it, and in what context to say it. And the officer should be alive to the fact that the giver of a statement doesn't understand. I offer to this court the case of Regina versus Zevekias, and I have a copy for the court and my friend.
My client was so scared and intimidated by Officer Dooley that she gave him a statement that today she is claiming was not voluntary. The court can assess for itself the character of Ms. Ryder. She is not, I would submit, someone who is a wimp or a pushover, for a lack of a better term. She has been in an industry for 35 years where she has paid her own way to graduate from truck driving school. Ms. Ryder is an intelligent and knowledgeable individual. It is almost incredible to believe that she could not understand the basic words of Officer Dooley's caution, or even ask questions if she in fact didn't understand. The giving of the statement by Ryder to Dooley was voluntary. I ask the court, no, I urge the court to conclude this. The statement was not given with the hope of advantage or a fear of prejudice. And in conclusion, I ask the court to rule the statement admissible.
Your Worship, I am offered a significant degree of latitude, and my questions can depart from the heart of the subject matter, so long as I have a point to be made, and I can assure the court I have a point and I'm getting there.
I'm going to allow this line of question, but you better get to the point, Counselor. The objection is overruled for now.
Officer, favorite donut, please.
Honeycrawler.
Officer, I'm going to suggest to you that on the morning of June 21st, 2011, the Tim Hortons coffee shop was late in baking your favorite donut, and as a result, you were willing to wait in lineup rather than go to the accident scene with haste.
I'd already placed the order. I was stuck there.
So, officer, I'm going to suggest to you then that maybe the accident you were dispatched to wasn't all that serious.
It was absolutely serious. I had just missed breakfast. I couldn't conduct an investigation.
When you finally did arrive on scene, how did you determine who was the bus driver and who was the truck driver?
It didn't happen like that. I was approached by a woman, and she indicated that she was the bus driver and that the other lady was the truck driver.
So, other than this hearsay evidence, I'm going to suggest that you conducted absolutely no independent investigation to make the vital determination.
I was satisfied that I had established the identities of all parties.
But now, looking back, officer, I suggest you feel differently.
No, I don't.
In looking back at the accident scene, did you make any note of skid marks or other important characteristics?
The only remarks I recorded was that there was extensive damage to the rear of the bus and correlative damage to the front of the truck.
You told the prosecutor that you had considered the existence of skid marks when making your ultimate determination of my client's culpability, correct?
Yes, that's correct.
But you didn't make a single note about skid marks.
I didn't, no.
But you did make note about police business, which we now know has more to do with the restaurant business than actual police business. Isn't that right?
I don't know how to answer that.
I'm suggesting to you, sir, that you make notes because you see the importance in recording them, because they're facts you will need to recall later. Do you agree with that suggestion?
Yes, I agree.
So, based on that, if you don't record that there were skid marks at the accident scene, it's either because there weren't any or it wasn't worth noting.
I can't say for sure, but I remember skid marks. I know that.
You continue to refer to my client's vehicle as an 18-wheeler, officer, and I've looked all through the Highway Traffic Act, and I can't find a single reference to 18-wheeler. Can you clarify?
Well, I meant commercial vehicle. I was just using 18-wheeler because that's sort of an industry term.
Well, excuse me, officer, but correct me if I'm wrong. Aren't you engaged to enforce the provisions of the Highway Traffic Act and not industry standards?
Well, yeah, I misspoke.
I have no further questions for this witness.
Anything arising out of that, Madam Prosecutor?
Take the stand, madam.
I must say this witness bears a certain resemblance to the officer Dooley.
Your Worship, I have canvassed this, and I can assure the court that there's no impropriety.
Could you please state and spell your name?
Janet Stocker, Janetstocker.
You wish to affirm or swear on the Bible?
I will swear on the Bible.
Place your right hand on the Bible. Do you swear to tell? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do so swear.
Ms. Stocker, what do you do for a living?
I'm a bus driver.
And how long have you been a bus driver, madam?
5 years.
Do you remember the events of 2011 that bring you here today?
I certainly do.
What date do you remember those events taking place?
It was June 21st, 2011.
Madam, can you tell us what happened?
Well, I was on Wilson at the stop sign, waiting for traffic to clear so that I could turn left onto 26.
What is Wilson?
But that's a street.
Please continue.
Well, there was a transport to my right up the road, and there was plenty of room for me to go. So I saw an opening, and I went. I was driving a spare bus, which I knew took a little bit longer to get going. So I was conscious of that. My left was clear. There was a vehicle across, but it was clear for me to go. So I turned left. When I was up to speed, the transport was on my bumper. I looked at my speed, confirmed that I was going 80. I traveled a few seconds longer, and she was still on my bumper.
Who is she?
That's the truck driver.
Continue, please.
Well, that's when I hit my brakes, just enough to flash my brake light, like sort of a warning to back off. She backed off a little bit for a few more seconds. But then, as I was approaching my first stop, I put my warning lights on earlier than I normally would, before the bend on 26, because she was so close. When I was slowing to stop with my four-ways on, and I didn't see my student at the end of the driveway, so I turned my flashes off. But in that second, when I turned them off, I saw the student come running down, so I turned my flashes back on. As I was continuing to slow, I was watching the